Good morning, everybody. We're going to go ahead and get started. Presenting today is Landon Toot. He's the COO and Chief Compliance Officer of Impact Healthcare Solutions. He has over 33 years of experience in hospital administration, sales, compliance, cybersecurity, medical practice management, and revenue cycle management. Landon is also an attorney practicing in health law, cyber law, regulatory compliance, elder law, privacy law, and dispute resolution. If you have any questions throughout the presentation, please use the Q&A feature, and we'll get to them at the end of the presentation. In order to get your certificate, you will need to fill out the survey that comes after the presentation's over. And with that, I'll pass it over to you, Landon.
Thank you, Brian. I appreciate that introduction and welcome everybody. I'm looking forward to speaking with you today on contract law. So I want to start off by saying the process of contract drafting and review is generally dysfunctional. I believe that is the case for two reasons. First of all, is the complexity of language, and the second is because of our copy and paste culture. Now, I cannot teach you contract law in an hour, but instead, my goal today is to convince you that you need expertise. Now, that expertise might come directly from you and you only, although I find that to be unlikely in most cases. Your lawyer might also have all of the expertise that you need, but I find that is equally unlikely to be the case. Now, why is that? Contract law is very complex. Certain healthcare contracts can be some of the most complex because our healthcare industry is so heavily regulated. You need legal expertise when you're drafting and you're reviewing contracts. However, no one knows your business better than you do. No one knows your opportunities, your risks better than you do, and certainly not your lawyer. The right expertise, I would argue, is likely a combination of the two. You, business owner, business operator, and your lawyer joining both of your expertise to get the right mix. Now, what roles should you and your lawyer play as you're drafting or reviewing a contract? Well, your role is to communicate the purpose, communicate objectives, communicate desired outcomes, and then also define the business process, like pricing, scope of work, etc. Now, what's your lawyer's role in that? Your lawyer should draft very clear, very concise, enforceable contract language. Your lawyer should ensure that you're compliant with state laws, conditions of participation with regards to Medicare and Medicaid or other CMS programs. Make sure that you're compliant with contract language with commercial insurances. Make sure that you're compliant with all federal laws, and we're going to cover a lot of those today. And then your lawyer should be helping you identify risk, and I think more importantly than that, making sure that he or she is explaining to you what your risk is in a way that you can understand it. And then after you go through that process, the most important part is you as the business owner, the business operator, have to make a business decision. A lawyer can give you as much information as they want, and you want to take that in and understand it, but ultimately you have to make a business decision where you're balancing business opportunity with risk mitigation. So normally if we were in a room all together, this would be more effective with a show of hands, but I want you all to think about to yourselves about the Oxford comma, the serial comma. Are you a believer in the Oxford comma, or are you not a believer in the Oxford comma? I wish I could see everybody showing their hands, but I'm going to assume, I see people are now raising their hands. Wonderful. You can raise your virtual hand. A lot of people raising their hands supporting the Oxford comma. So let's talk about the Oxford comma as a fun example. We're going to talk about the $5 million comma. So the Oakhurst Dairy case, this dispute centered on the interpretation of law that exempted certain activities from overtime pay in the state of Maine. Now, this exemption included packing for shipment or distribution of perishable foods. And you can see the language of the law right there: the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of perishable goods. So this Maine law required overtime pay at 1.5 times regular pay. But again, the law does not apply to those things. So what happened here? These drivers employed by the Oakhurst area argued that without a comma before the words or distribution, the law only exempted packing, whether or not that packing was for shipment or for distribution, but it isolated the word packing and not distribution itself. Now, Oakhurst Dairy argued that distribution was a separate exempt activity. The case involved lots of arguments about grammar, punctuation conventions, legislative intent, et cetera, et cetera. The district court originally ruled in favor of the Oakhurst Dairy, but the appellate court came back and overturned that decision. It found that Maine's law, because of a lack of that comma, found the law to be ambiguous, and therefore it interpreted the law in favor of the workers. Now, the Maine legislature went back and amended the law and put a comma in there, but ultimately the Oakhurst Dairy, they settled the case. It was a $10 million claim. They settled the case for $5 million of back overtime pay. So that is the $5 million comma. Now, legal disclaimer. Our attorney can't give a presentation without a legal disclaimer. Everything I'm giving you today is for educational and informational purposes only. Nothing is legal advice. I am going to include a couple of pieces of contract language in here. Don't copy and paste those. Don't use those in your contracts because these are not written for you, okay? Okay, agenda. I'm going to hit some rapid Q&A really quickly. I'm going to give you the full basics of contract law. I'm going to briefly show you different forms of contracts. We're going to talk about the importance of language. I'm going to hit some very particular sections of agreements, and then I'm going to give you some information on special healthcare contract provisions. So these are some questions I often get about contracts. How long should a contract be? Well, it depends. First of all, you do not measure the quality and effectiveness of a contract based on its length. What matters is whether the contract is effective at mitigating your risk and facilitating the business transaction. Remember, a lawyer should not be telling you, no, you can't do this. A good lawyer is going to tell you how to do it, okay? I can write a fantastic contract that fully protects you, is super tight in one page. I can also write you a 100-page contract that does absolutely nothing with you. So length of a contract is irrelevant. What matters is the substantive content, whether or not it protects you and helps you facilitate a transaction. Question number 2, does it really need all the legal jargon like whereas and heretofore? That's an easy question. No, it does not have to have that. Number 3, does it have to be a written contract? Well, it depends on the type of contract, and I'll give you some of that information towards the end here. But remember, importantly, not all contracts have to be written. You can enter into an agreement verbally, again, depending on the type of agreement. Can I just copy and paste for other contracts I find online? Well, I've already sort of hinted at that. You can, but I certainly would not advise it. My favorite thing are these companies, these legal service companies that are showing up online where you can go and you can buy a contract template. One of my favorite things is when they advertise, hey, our contracts have been vetted in court. These contracts have gone to court and the plaintiffs or the defendants using our contract template won. Well, my question is, why would you want to copy or use a contract template that someone found was poor enough that they would have a good shot at winning in court? I don't want my contracts taken to court at all. If another party looks at my contract, I want them and their attorney to realize that there's no way they could go to court and win, okay? So I would advise, if I were advising you, I certainly would not utilize a contract that I find online or copy and paste. You need expertise to vet that. Number 5, can I just put everything into an email instead of a formal contract? Yeah, you certainly can. Again, I wouldn't do it. Number 6, do I need different contracts for each service or product? No, you don't necessarily need that, but it might be a good idea in case you think you get to a point where you're going to have multiple engagements under like a master services agreement, or if you think there might ever be a time where if you're engaged with a party for multiple different types of products or services, and you might want to carve those out or in one but maintain another, might be a good idea to split it up into parts where you have a master service agreement and multiple scopes or multiple purchase agreements. Number 7, do I really need to read the whole thing before I sign it? Yes, you do. And more importantly than that, you need to make sure that you understand everything in that agreement. Because in every state, to my knowledge, if you sign something without reading it, you're responsible for what you signed. Okay. So yes, you do need to read it. And yes, you do need to make sure that you understand what that language means in the contract. Number 8, can I just change the contract later if I need to? Yes, you certainly can agree with the other party to make modifications of things that don't change the overall meaning or substance of the agreement, like dates or typos, things like that. You can agree mutually to amend an agreement substantively as the agreement permits. A lot of contracts are going to have amendment clauses in there that lay out a process for amending an agreement. Can I ask the vendor to lower the price or do something extra? Sure, you can. You can do that, but realize, I see this a lot in healthcare, realize that generally in contract law, you have to provide something in exchange for that modification in order for that modification to be binding or enforceable. Now, there are some exceptions for that, but there's got to be a quid pro quo. If we enter into an agreement and I'm going to ask you to do something extra, or if I'm going to ask you to lower your price, I'm receiving an additional benefit. In order for that modification to be enforceable, generally, I've got to provide something in exchange for that. So that again, there's a quid pro quo. Number 10, my favorite question, why do I need a lawyer? Aren't you just trying to bill me? Well, yeah, lawyers, we need to make a living, right? We've got to pay off student loans and things like that. But I want you to think about engaging a lawyer to help you with your contracts differently than you want. I see a lot of healthcare organizations in general, not just healthcare, they don't want to pay for the lawyer services, and so they feel like they can do it themselves. I like to think about that as driving a car without a seatbelt, or think about spending some money, a couple of $100, $200-300 an hour, maybe to have a lawyer look at your agreements, let them spend 1 or 2 hours looking over your agreement. It's like buying an insurance policy, and buying that insurance policy is going to be significantly less than it would cost for you to move into litigation. So think about having your attorney look at your contracts, helping you draft contracts as an insurance policy. Okay, the 4 basic principles of contract law. This is very oversimplified, but essentially in order to form a contract, you really have to have just 3 things. And then the 4th is kind of an overarching compliance measure. The formation of a contract requires a bargain in which there is a manifestation of mutual assent to the exchange and consideration. Okay, that means you have to have offer and acceptance. Okay, mutual assent means offer and acceptance. I have to make you an offer and you have to accept it. 2, there's got to be consideration. Consideration is your promise to pay or provide something, and there's got to be consideration on both sides. I have to give you something in exchange, you have to give me something, okay? And then for the contract to be enforceable, the parties have to be, they have to have the legal capacity to contract. And then, of course, the purpose of the contract obviously must be legal. You can't contract with somebody to murder someone or commit a crime, okay? Contract forms. I am not going to go through all of these. I just want to put this up here for effect so that you can see all the different types of contracts. Some of them function very similar to each other, but some of them function very differently. It's important. Again, you need expertise to understand what contract form is best for whatever your particular engagement is, and you need to understand how those things work. So this slide is more for effect than anything else, but just be aware, like I said, contract law is complex. Now, this one is for fun. I don't think that you're necessarily going to be able to hear the audio, but you don't have to. I'm wondering how many of you remember Pepsi Points back from the late 90s? I'm going to play you 2 versions of the same commercial here. Yeah, we've got some people remembering Pepsi Points. I'm going to play you 2 versions of the same commercial. Here's the first one.
Introducing the new Pepsi Stop That Law. What Pepsi you drink, the more great stuff you're going to get.
Sure beat the boss.
All right, so we saw 7 million points for a Harrier jet. So let's look at the second commercial. This is the same commercial, but slightly altered. See if you notice the alteration.
Introducing the new Pepsi Stuff Catalog. More Pepsi you drink, the more great stuff you're going to get.
Sure beats the boss.
Well, sorry about that. I played the same commercial twice. Let me try that again. Here's the second one.
Introducing the new Pepsi Stuff Catalog. Pepsi you drink, the more great stuff you're going to get.
Sure beats the boss.
Okay, so there we saw now the Harrier jet in the second commercial was 700 million points, and they put it the parenthetical at the bottom, just kidding. Well, the reason for that is Leonard, like me and most other kids who saw that commercial, we wanted the Harrier jet. Well, Leonard figured out a way to go after it. So Leonard, here in the case Leonard v. PepsiCo, obviously this case resulted in the alteration of the commercial for the second version. Leonard claimed that that was a legit offer by PepsiCo, and he found a loophole. When he read in the terms of service the user rules for the Pepsi Points competition, he found where you could purchase a Pepsi point for 10 cents. So he had a buddy. He went and talked to this older man who was a friend of his, who had apparently lots of money to give. And so lo and behold, Pepsi received a check for $700,000, totaling up 7 million Pepsi points. And Leonard wanted the jet. Well, litigation ensued about 2.5, 3 years later. PepsiCo won, but they expended an incredible amount of money arguing this case. PepsiCo won eventually, stating, and the holding was that no reasonable person would have believed this to be an actual offer. Very fun case, one of my favorite cases in contract law. So that was for fun. So let's talk about the importance of language. So we've got 5 things here I want to cover. And versus and/or. You see these in contracts a lot. I propose to you the best way to do this is X or Y or both. This is the language of inclusion, the language of exclusion, and the language of discretion. Okay, so if you use and, or if you're using or, which is it? If you want to offer both, don't put and/or because it's ambiguous. You're going to hear me talk about ambiguity a lot today. X or Y or both is the right way to write that. The next one, language of obligation and discretion, shall, will, must, and may. Okay, again, obligation, shall means must. Will has it, there's question of time. Okay, if you're saying this party will do this, again, it's ambiguous. When will that party do it? They shall do it, they must do it, versus the party may do it, gives them the choice, right? That creates an opportunity for that party to use its own discretion as to whether or not it's going to perform that action or not. Number 3, best reasonable materially and substantially. Again, these are just examples. There's lots more examples of each one of these, okay? This is the language of performance. Could be the language, you could call it the language of quality. You know, to what degree of quality will someone perform something, or will someone provide something? So what the question is, what do these terms mean? And then who gets to decide what they mean? Again, these are all areas of ambiguity that can cause you and your other party, your contracted party, to potentially get sideways in terms of arguing over definition, okay? Number 4, creating uncertainty. So including and but not limited to, right? So this creates uncertainty. So this, obviously, if it includes something, there's a list of things that are included, But if it's not limited to this very specific list that I'm including in this contract, my question is, how long is the list? Are there any exclusions to the list? Again, this creates ambiguity. References of time, number 5, immediately, promptly, as soon as practicable. Again, there's many, many other examples of this, but you have to ask, what is possible? If you write something into a contract where a party must do something immediately, is that really possible? Can they really do it immediately? Maybe they do it promptly. What does promptly mean? As soon as practicable. Who gets to decide when something becomes practicable? Who gets to decide that meaning? So it's important to be clear in all of these areas. All of these are danger areas that can create ambiguity. Ambiguity in a contract is dangerous. It can be leveraged to your benefit when used the right way, but ambiguity leads to dispute and conflict. Another area, pronouns, it, they, them, etc. Don't use pronouns in a contract. State the parties to the contract and name them every single time you address a party. Now, what about defined collective terms like party, parties, lessor, lessee, employer, employee? You can use those. It's good to try to avoid defined collective terms, but if you're going to use them, make sure you very clearly define them at the beginning of your agreement and make sure that you refer to them correctly, because often I've read contracts where there were definitions, party definitions at the beginning of the contract, and then they were not referenced properly in the body of the agreement. So try to avoid pronouns if you can. Or excuse me, avoid pronouns, try to avoid defined collective terms if you can. Okay, undefined terms like industry jargon, technical terms, terms of art, either don't use them, kind of soften your language, use terms that are more clear that anyone even outside of the industry can understand. Either don't use them or very clearly define them, and then make sure that your definition and the other party's definition, make sure you agree on those definitions. So as you're reviewing a contract, make sure you're reading the definitions of those terms so that you and the other party are on the same page. If you're drafting them, reach out to the other party, send it to them, and make sure that your definitions are clear. Because again, many people use, especially in healthcare, we use the same words to actually refer to different things, or the same thing with different parameters and different conditions. Be very clear and detailed with your definitions if you're going to use any of these categories of terms. Again, I've said this a couple of times, your words should be very clear. They should be very specific. Your metrics, if you're including performance metrics in your contract, they should be quantifiable. Offer examples of your metrics. Make sure that both parties understand the mechanism or the formula. Make sure that they understand the parameters and anything that might come in and influence those parameters. You've got to make sure that you calculate, that everybody understands how someone is going to be measured. Otherwise, again, the ambiguity can lead to litigation. All right, let's talk about some specific sections of the agreement where I see a lot of mistakes or problems in contracts. The preamble at the very beginning of your contract. Make sure that you name the legal entities who were entering into the agreement. I've seen, particularly like with physician agreements, we're going to contract with physician X, when in reality, we should not be contracting with the physician. We should be contracting with the physician's legal or liability, a limited liability company, or the professional company, or something like that. Okay, not the physician, not the person themselves, but the legal entity. Make sure, and also be aware that companies use DBAs often. Make sure you look up the actual legal name of the entity. Again, I mentioned defining terms. The preamble is where you can define a lot of your terms. Make sure you're very specific in your definitions and that you agree with the other party on those definitions. And then very important for contract law, in the event that you do get sideways with the other party, identify the headquarters. That's very important in the event that you might have to take legal action against the other party, or they're going to take legal action against you. Understanding and defining the headquarters, the principal place of business, where the legal entity is domiciled and registered, all of those things are important. So identify the headquarters in the preamble. The premises. Whereas lawyers must identify their hourly rates, and whereas clarity is overrated, and whereas English is for amateurs, now therefore let's use big words nobody understands. Do you have to have this stuff in the contract? No, you absolutely don't. Why is that stuff in there? Well, lawyers are creatures of habit, and we like tradition, and we like to sound really smart, and we like to bill for being really smart. So, you know, is this stuff required to be in your contract? No, it absolutely is not. Are you going to find contracts with this in there? Absolutely. Okay, I've mentioned definitions a couple of times. I spent a lot of my time in the revenue cycle management sector of healthcare. And so here's just some examples of things where my RCM company might refer to or define some of these things just slightly different from another RCM company, which might define these things slightly different from your healthcare organization or a provider's office or something like that. So these are just some examples where we all need to be on the same page. Make sure that you're defining things clearly, and particularly acronyms. Make sure that if you're going to use an acronym throughout the contract, write it out, define it upon the first usage, and then you can use the acronym through the rest of the contract. If you want to be super clear and avoid all ambiguity, don't use acronyms at all. Spell it out every time. Now let's talk about services. I sort of addressed this in the Q&A. Consider using a master services agreement. There are going to be a lot of things that you can agree to that won't change as you might change scopes of work or add or take away services or products in the future. It might be more efficient for you to agree to those things, again, that are likely not to change, and memorialize those in a master services agreement. And then as you grow into a partnership or a business relationship with another organization or another contractor, you can then use different exhibits for different scopes of work or products. Now let's talk about quality. I see a lot of this, particularly in service agreements, things like phrases like commercially reasonable, generally recognized industry standards. Again, these are ambiguous. We see these repeated over and over and over, but there's often not clearly any definition of what those things actually mean. So this would be an example of finding something where you can measure quality, but make sure that it's quantifiable, which can be a challenge depending on what you're contracting for. All right, something I like to include in my agreements when I'm contracting with any other company, if I often make this mutual, if either party becomes subject to an investigation or a lawsuit involving the subject matter or the scope of the contract, one party will notify the other party so that they can prepare a defense if necessary. Okay, so if one of my clients is under investigation or becomes subject to a lawsuit, I want them to let me know if it involves things that I'm doing for that client. Okay. Obligations, I see contracts go sideways very often when I'm working with hospitals and medical practices around the country as a consultant and as an attorney. I see them, communication is a big problem. I think it's a good idea for your organization and the other party to the contract to designate points of contact with regards to the agreement itself, and then a second point of contact, if necessary, on both sides to address the subject matter of the contract, right? So one party on each side to deal with the contractual agreement itself, and then possibly different points of contact. They could be the same, but maybe different points of contact on either side to talk about the services or the products, okay? Some additional provisions that I like to include on that same note, cooperation clauses. Both have to cooperate in good faith. Efficiency, we're going to take all steps necessary and reasonable. Again, what do those terms mean, right? What's reasonable and what's necessary? Business associate agreement, always refer in the contract to your business associate agreement, which often is going to be a separate agreement, but I always like to refer and incorporate that BAA into the main agreement. Some other things, again, I like to specifically designate representatives where that's appropriate. You need to have, if you do this, you need to have information in your contract or terms in your contract that allow changes to those representatives. Could be following a certain amount of notice. It could be upon resignation, termination, death, or disability of an existing representative. So that gives you the ability to change. It also gives the other party ability to change, and you create conditions under which that can happen. Records and record retention. Who's responsible for keeping originals? That question should be asked, particularly if you're, obviously if you're moving data back and forth. That's certainly pertinent in my industry and revenue cycle management. And then record retention requirements. Provided some guidance here. These are statutes that you can use if you want to refer to them in the contract. With regards to required record retention, your states are going to have separate record retention laws. Most of the time they'll align with the federal requirements, but you need to check your state laws as well. When I get asked, what should my record retention policy be? I always recommend 10 years. And there's a reason for that. The last one on there, 31 USC, section 3731, subpart B, that is the False Claims Act. And that is, under the False Claims Act, there is a 10-year look back period. And that is the largest record retention period I am aware of in federal or state law. Okay. So I recommend my clients and my businesses to have record retention policies that last for 10 years, because if you ever get hung up in a False Claims Act matter, the federal government can come back in and look back 10 years. And then performance reporting. Understand, I like to figure out as much in advance as we can. We figure out what's important to each party, figure out what we're going to report, how we're going to report it, how are we going to measure it, what do those measurements mean, and then talk about how we should be, what we should be taking away from that reporting. Excuse me. Term and termination. Be aware that, if you are engaging with a service provider, this information, I see people mess up on these clauses as well. So termination for failure to pay. If you get behind and you have a vendor who has a termination for failure to pay clause in there, they could cease services, okay, if they've got this in there. So look for these sorts of things. You don't want to you don't want to contract out a mission critical service and something happens and you get behind, and you can make provisions in there for force majeure clauses and things like that, right? But be careful if you've got a contractor who could cut you off and essentially shut down your operations or disrupt your cash flow. So be on the lookout for these type clauses. Also, no notice provisions. I see problems with this all the time. One party or the other wants to exit an agreement and they think they're giving proper notice when in reality there is either a no notice clause in there or a notice clause in there that provides for specific notice process. And if you don't comply with that, then you have not effectively given notice, and that may mess up your plans. So be on the lookout for these particular clauses. Warranties and indemnification. What is a warranty? Well, a warranty is a statement of fact. Warranty creates a legally binding commitment that you must offer, or the other party to the contract must honor. If you want a guarantee to something, this is where you ask for it. This is where you negotiate that guarantee. It should be in the form of a warranty. And then what is indemnification, and should it be mutual? Indemnification is a commitment of one party to pay for or reimburse the losses of the other party, and also to defend the other party against claims. So you want to carefully define what specific events or circumstances might trigger indemnification, and you want to be as precise in that as possible. I mean, let's face it, warranties and indemnification, a lot of times we just read over those, gloss over those. We may not read them at all. A lot of times they can be very confusing, but these are some of the most important clauses in your contract, because it might trigger you to have to pay to defend a contractor, okay? Some limitations you might consider limitations such as caps on liability, caps are time limits for bringing claims. You also want to exclude things like negligence, and intentional misconduct, recklessness, things like that. And then with the question of should it be mutual? Well, it depends on the risk involved. Usually when I'm negotiating with another party about indemnification, I like to draft the language so that we both share in the risk. Attorneys, if you have a good attorney, well, I shouldn't say that. Many of you likely have attorneys, if their sole goal is to protect you to the greatest extent possible, they're going to have a really restrictive indemnification clause in here that the other side may not see as fair. Okay. And then there's opportunities to negotiate backwards and forwards. I often, this is my personal opinion, I tend to see that as more of a waste of time. I would rather redraft indemnification language so that we both share in the risk in a way that's fair, and promotes partnership and promotes us being able to enter into a business relationship and do business together. When you write a very one-sided indemnification clause, and this really goes for a lot of the terms in a contract, if you're very one-sided, it can come across adversarial to the other party, and it does affect your ability to negotiate some of those terms. So just keep that in mind. Again, ultimately, it's about asking your lawyer, you know, what is your risk and what should be done to protect you and your organization, and then ultimately you have to balance that understanding with being able to make a business decision with regards to your opportunities to engage in a business transaction, right? So ultimately, it's an informed business decision that you're making here. Okay, and again, this is an example of some mutual indemnification. Again, don't use this. This is not written for you, but it's just an example, and I'm not going to read it. But there it is. This is an example of limitation of liability. I've had people ask me, why are certain sections in a contract bolded in larger print and all caps? Well, it has to do with litigating contracts in contract law. It is to make sure that I'm showing you that I'm limiting my liability here, and you can't say that I buried it in the contract. No, I intentionally brought your attention to it by putting it in all caps and bolding it. And this is saying that, you know, my liability in this agreement is limited by all of these things. Okay. Okay, now let's talk about warranties. This is another one of my favorite cases. It's Hawkins versus McGee. This is essentially a patient went to a surgeon, McGee. He had a severe burn on the palm of his hand. And McGee, the surgeon, guaranteed to make a, quote, 100% good hand by removing the scar tissue and replacing it with a skin graft from the patient's chest. Well, the skin graft, lo and behold, caused thick hair to grow on Hawkins' palm. And so naturally, Hawkins wasn't excited about hair growing on the palm of his hand. So he brought a lawsuit against McGee on the ground that McGee violated an alleged warranty for the success of the operation. And so the running joke here on this case is shaving is not a remedy. All right, back to sections of an agreement. Privacy and confidentiality, because you're healthcare organizations, you definitely need to have this information in here. These are the sections where you're going to refer to all of your HIPAA provisions. You want to reference your BAA here. And you might even, I've even written some contracts where I've referenced certain sections or specific sections of the BAA. You can put confidentiality information in here that does not cover protected health information. It covers everything else. There's a difference between protected health information under HIPAA versus proprietary or confidential information. Two different things, okay? You want to define when you can and when you will disclose confidential information. You also put all your intellectual property stuff in here, and I like to make all of this mutual. We're both going to, with regards to intellectual property, confidential information, we're going to protect each other and we're going to do what's fair and work together. So I like to make all of this mutual. Now, employment and subcontracts. You want to have information in there. You want to understand that if you are going to partner with a service provider or or someone, a supply provider, a supplier. How many downstream subcontractors do they have? And you might want to write some restrictions in here to address that. You certainly, from a BAA standpoint, want to include provisions in your BAA and potentially reference that in your agreement, that everything in your agreement and everything in your BAA applies to the other contracted party, but also applies to all of their subcontractors as well. And you need to make sure that your contractor is notifying their subcontractors and the other things you can do, some due diligence you can do to ensure compliance with that. But that's a different webinar. All right, non-solicitation clauses. This was going to be a big deal up until September 4th, I think was the date. There was going to be a national prohibition on non-compete agreements with employees, and there was a debate that was raging up until I think it was a Texas federal judge sort of shut that down nationwide for the time being. There was a raging legal debate over whether or not you and I, as businesses, having non-solicitation of employees functioning effectively as a non-compete agreement for individual employees. And so my answer was going to be to that in advance of September. My answer would have been, we're not sure if you can include non-solicitation provisions, meaning I can't solicit your employees and you can't solicit my employees for a period of 2 years or whatever those terms may be. Right now, because the lawsuit that was thrown out, not a lawsuit, excuse me, but the measure was thrown out, nothing has changed with non-solicitations. So you can include non-solicitations for employees in your agreements right now. If this comes back up, it probably will go through an appellate process. If we end up having a ban on non-compete agreements nationwide, there's going to be guinea pigs going through litigation to determine if you and I as businesses having non-solicitation agreements function effectively as non-competes and whether or not those will or will not be prohibited in our contracts moving forward. So we'll keep an eye on that as we go forward. Dispute resolution. I like to stay out of court. Okay, so if you're going to get sideways, I like to include information in here, a process for dispute resolution. Okay, so first thing we're going to do is we're going to negotiate in good faith. If that doesn't work, then we're going to mediate, and we're going to write a procedure in here for mediation on how we select a mediator, whether or not we can do it virtually or if it has to be in person. And then if we can't mediate it in a specific period of time, then we're going to move to binding arbitration, and we're going to define where we're going to get the rules for arbitration. How do we select an arbitrator? All of those things. Okay. And then bolded and in caps at the very bottom here, we understand that we might, excuse me, get sideways, and we're both waiving our right to jury trial. Okay, so we want to avoid litigation. Negotiation certainly is cheaper. Mediation certainly is cheaper. Arbitration may or may not be cheaper. It depends on the kind of dispute you're in. Arbitration sometimes can take longer and be more costly than litigation, believe it or not. Generally, that's not the case, but it does happen. So I like to include a process for dispute resolution here that will keep both of us out of court in the event that we get sideways. A couple things here. Counterparts just means that both of you can sign agreements separately and combine those together to make one agreement. So you don't have to necessarily sign the same document as long as you combine them. Force majeure. One thing I want to point out here is I'm seeing a trend of, especially since the Change Healthcare debacle, we're starting to include provisions in force majeure clauses for cyber breaches. Okay, that's another webinar as well, but be aware that some are starting to put that in their force majeure clauses. Obviously, that would not cover things like negligence and misconduct or intentional misconduct. But you also want to, if you're going to do something like that, you also want to make sure that your language in there aligns with the language in your cyber policy, and you should have a cyber policy if you don't. I addressed notices already. I kind of went into that in greater detail earlier. And then your signature page and your initials, make sure that you have someone signing your agreement who is authorized by the other party and your organization to sign the agreement. I have seen disputes where one side claimed the other party was not authorized to sign the agreement. Okay, so make sure you've got the right people signing. Exhibits. if you're going to get sideways in an agreement, it's usually going to be in a statement of work. I've seen some very horrifically badly written statements of work and confusion over calculation of fees. Be very specific. I like to tell people to write your scope of work in terms of ownership. Who owns every step of that process? Compliance with applicable laws. These are some things that either you need to have references in your contract, or you need to be aware that these laws can influence your contract in how you draft it, things you include and things you exclude, okay? I'm going to cover a few of those in terms of some types of healthcare agreements, the most common ones. Facility leases, I'm going to focus on Stark Law and anti-kickback. Obviously, Stark Law being specific to whether or not a physician is involved in the agreement, okay? And so for facility leases, it must be a written agreement signed by both parties. The terms got to be at least 1 year. If you enter into an agreement, and this is going to be true for several of these, if you enter an agreement for a year and the contract ends, or both parties exit the agreement inside of that 1 year, you cannot re-enter into a new contract during that 1 year period with the same party. If one of the parties is a physician, okay? You must specify the exact premises and the space. And you can see the Stark and anti-kickback aspects of that piece. Aggregate space cannot exceed that which is reasonable and necessary. When you read through the laws, you're going to see the phrase reasonable and necessary over and over and over, and that relates to fair market value. Okay. Now, what does reasonable and necessary mean? That's a great question. There are some there are methodologies for determining that in different geographic areas. Okay, and that's again another webinar. Rental amounts must be set in advance and must be consistent with fair market value and not take into consideration the volume or value of referrals or other business generated between the parties. And you can see again the Stark and anti-kickback provisions there. And then the arrangement again must be commercially reasonable, even if there are no referrals made. Again, specific to Stark Law. Equipment leases and supply agreements. You see a lot of the same stuff here. It's got to be written in agreement. Term has to be at least 1 year. Reasonable and necessary for legitimate business purposes. The equipment must be exclusively used by the lessee during the term and not shared with or used by the lessor or person or entity related to the lessor. Again, if you start sharing equipment, you're giving a benefit to potentially a physician without compensation. So be careful of that. The amounts, again, must be set in advance to consistent with fair market value. And then the arrangement must be commercially reasonable, even if there are no referrals made. Personal service agreements. Again, a lot of the same information here. Must be a written agreement. Term must be at least 1 year. You must specify the exact services, must be reasonable and necessary for legitimate business purposes. And it says rental amounts. It should not be rental amounts, but it should be the fee amounts must be set in advance and consistent with fair market value. So what are personal service agreements? Here's some examples. Management agreements, billing service agreements, medical director agreements, interpretive service agreements like radiology, for example, pathology, emergency room and on-call coverage agreements, and any kind of consulting agreement. So your business associate agreement, let me address this really quickly. Some things that that are very important with regards to BAAs. The number of times that I have sent a BAA that I drafted for my revenue cycle management company to a hospital or a medical practice, and they just sign it and send it back. And I can't tell you how often that happens all the time. Okay. A lot of times I will ask the healthcare provider, do you have a BAA that you would like to send me that I can review? And the answer is no, we'll just use yours if you have one. Yep, I do. And it's a lot of it's mutual, but some of it favors my company because my job is to protect my organization, right? So you need to read your BAAs and make sure that you've got information in there that certainly protects you, but hopefully protects the arrangement, hopefully protects the business relationship, not just you. Okay. But some things you really need to pay attention to in your BAA. Again, force majeure. I referenced this earlier. Is a cyber breach an act of God? Well, it potentially can be. If you've done everything you possibly can to mitigate the risk of a cyber breach, no one is 100% hack proof. Even the federal government gets hacked all the time. Okay. However, if you might be deemed to have been negligent, an example would be if you have an employee who has not gone through a lot of training or has not spent the time they needed to on cybersecurity training, and perhaps they clicked on a link in a phishing email and disclose their access credentials, and that that threat actor enters into your IT environment, your network, and maybe you don't have multi-factor authentication enabled, as was the case with Change Healthcare, right? You do all of those things, then that might be a solid case for negligence, okay? And that would not be covered under force majeure. Now, breach notification. Who is responsible for notifying patients in the event of a breach? Who pays for it? These can be key areas of negotiation when you're trying to execute a BAA. You can delegate your responsibility to a third party in the event that, let's say, you're using a contracted medical billing company or another service provider, and they have a breach which affects your patients. Okay. If you can potentially negotiate into your BAA that if something like that happens under these specific conditions, you third party subcontractor have to assume the cost and facilitate notification of all of our patients. Okay, so those are points of negotiation that you might want to consider in your BAA under specific conditions, right? And then what are the limitations of that? So let's now talk about limited liability. Can a party limit its liability for damages in the event of a breach? Well, I gave you an example a moment ago of, say, a threat actor exploits your software and then enters into the other party's network. I would argue that you should not be held liable for damages beyond the initial compromise. If the other party, if their environment lacks proper security measures, okay? So I gave you the example that's very similar to the Change Healthcare breach, where there was a phishing email and access credentials were compromised. And then there was, in Change Healthcare breach, there was a single sign-on with unrestricted access to 100 or so lateral systems, okay? If the other party, if your system is compromised and that allows access into a contracted party's environment, you should not be liable if it's deemed that the other party has failed in implementing proper network segmentation and what's called least privilege principles. Okay, if they don't have their stuff together, you're not liable for that. You might be liable for the initial compromise, but you should not be responsible for the security posture or the controls present in another party's environment. Very important when you're looking at BAs. Okay, last one. Don't drink and deal. Okay, this one's for fun. So in the case Lucy v. Zimmer, the Lucys sued the Zimmers to enforce a contract where the Zimmers agreed to sell their Virginia farm to the Lucys. They had been after this farm for years and years and years, and they all were together at one point, drinking and joking and having a good time. In the midst of this, Mr. Zimmer created a handwritten document as a joke that read, and you can see a picture of the actual document here. It read, "We hereby agree to sell to W.O. Lucy the Ferguson farm, complete for $50,000, title satisfactory to buyer." Well, he did it as a joke, but Zimmer later argued he'd been drunk and thought it was all a joke when they wrote up the agreement. Unfortunately, the Virginia Supreme Court found an enforceable contract and ordered specific performance, which means they had to turn over the farm. And with that, that's all I've got. I am happy at this point to take any questions that you have. Again, I cannot answer specific questions that are about your specific situations or agreements, as I cannot provide you legal advice. However, I'm happy to do my best to answer any questions that any of you may have at this point.
We have a couple of questions, Landon. The first one's a little confusing, so I'm going to say it how I think it was intended to be asked. If the original contract does not state that either party can amend or change certain parts of the contract, can they still amend the contract at a later date?
Yeah, absolutely you can. That's a great question. Hopefully your contract does have a process in there for amendments, but both parties can always mutually agree, and it should be in writing, right? You should write an amendment and both parties sign it, just like you're executing a new agreement. But you certainly can put together an amendment or an addendum, whatever you want to call that. And both parties, as long as, again, there's mutual consideration, quid pro quo, if you're making a change to it, or if you're just making a moderation to the contract, some language or something, maybe to make it more clear, write it out, both parties sign it, incorporate that into the agreement, and you should be good.
The next question is, how do you recommend handling contract terms that may survive the termination of the agreement? So, for example, reimbursement for a provider with a payer, disparagement, prohibition, access to records, and other miscellaneous contract terms.
Yeah, so that's a big question with a big answer, and it depends, right? So there are going to be certain things that have to survive, like record retention, for example. There are other things you mentioned in there, paying physicians and things like that. What I do with regards to those types of surviving clauses is I negotiate them out of the contract up front, right? So if some of those are contained in the contract, then you're going to be managing that contract for a while, even after termination of the agreement, right? So you're still going to have ongoing obligations under that agreement, but the termination of the agreement results in no new obligations coming forward. Okay, so you're not gonna take on any new neither side will take on new obligations, but anything that's written in there as in the survivability clause, and again, you're going to have some federal and state requirements of survivability, then you're going to be managing that potentially for a while, depending on what it says. But that's something you definitely want to pay attention to when you're drafting the terms of your agreement, for sure. That was a very evasive answer to that question.
I think that's all the questions that I see. I did have several people ask about polling questions. Obviously, there were no polling questions, but you do have to be on the webinar for 50 minutes to get credit. I think we just got one more. Concerning record retention, does the law specify specific records? If no, should you list these out in your contract? Are emails considered records?
So record retention, the requirements are all going to be codified either in federal law or state law. Okay, and and a lot of times they are specific to certain record types. Okay, particularly in state law. If there's a conflict, then what's called the preemption doctrine rules, where federal law is going to supersede state law where there's a conflict. Okay. But I don't know that I've seen any conflicts in a long time. So yeah, if you are contracting for a particular type of service, like radiology or lab, for example, then you certainly can be specific about record retention. This particular type of record has to be in accord, and I actually would cite the statutes, right? If there's a federal and state statute governing that, I would refer to the statutes and maybe even give the specific language of the statute in the contract. I like to do that. But more than that, in my work, I'm working with hospitals and medical practices and laboratories and all sorts of healthcare provider types. And so it doesn't make sense for me to have to micromanage that. And that's why I gave the recommendation. My record retention clauses are 10 years, because even if you have a provision, which I want to say lab is like 2 years in a number of states. I think that's right. Even there, if you get embroiled in a false claim act litigation, federal government can come in and look back 10 years. Okay, so even if you're specifying 2 years here, 5 years here, 7 years here, and you're referencing those, and that's your obligations, you still have exposure for 10 years under the False Claims Act. So I like to not even worry about all of that and just make it a blanket. Hey, if we're going to do business together, we both got to retain records for everything that we do together for 10 years because of the False Claims Act. If you want to ignore that and assume you'll never get involved in that more power to you, and you want to be specific, go ahead. I always recommend 10 years.
And one more, and then we're technically out of time, guys, but one more. How clear is using medical and billing records versus medical, financial, administrative, and billing records? Is that a
Well, and then you can lump all of that under another category being the legal record, right? And I'm not sure I understand the question. I think is the question, should we be clear about the different types of records? Maybe.
Yeah, that's kind of the intent, I think, from what I'm taking from it.
Yeah, I mean, in terms of, so I would look at it in terms of functionally, what things do I have to include in the agreement, and why I'm including, why I would separate those into categories. And it's going to be privacy and security under HIPAA. It's going to be protecting intellectual property, which is going to pull in confidentiality things and intellectual property law. And because of that, that's where I'm really distinguishing the types of records, whether it be medical records versus business records. Okay. And really you can take medical records and lump them under business records as well. And not to give you, a big legal lesson here, if you're involved in litigation and there's discovery, there are, and you're talking about attorney-client privilege, and then you're talking about being able to present information in a court of law as evidence. And you start talking about evidence law, there's the hearsay rule. And there are exceptions to the hearsay rule. And then you start talking about business records is an exception to the hearsay rule. Okay. So, and medical records then are lumped into business records as part of that exception to the hearsay rule. So it can get very complicated. You want to try to keep it as simple but specific as possible, if that makes sense. Again, privacy and security, protected health information, confidentiality provisions for your business records, meaning financials and things like that, policies and procedures, and then intellectual property. That's how I would categorize it, and I wouldn't get into I would try to avoid getting into the weeds of everything else, if that makes sense.
I've had several questions about whether handouts will be available later. I'll check with HFMA. Landon, are you willing to share your PowerPoint if people would like? So I'll check with HFMA, but obviously take down Landon's information there, and if you want to use that as a reference, he can provide that to you if HFMA doesn't send it out to everybody.
Yeah, if anybody wants a copy of that, I can provide it to you in a PDF. Just shoot me an email at either one of those two email addresses is fine. I'd be glad to share my PowerPoint with you. Happy to.
All right. And with that, we're a little bit over, but appreciate everybody's time. Landon, appreciate you presenting. Just as a reminder, make sure you fill out the survey that's going to come out in order to get your CPE credit. That's all we've got. Appreciate it.
Thank you, everyone.